A temporary layoff usually refers to a situation where an employee temporarily reduces or entirely stops an employee's work without pay, typically without terminating the employment relationship. There are rules that employers have to follow when they decide to lay off an employee. The maximum duration that an employee can be laid off for depends not only on the laws in the specific province of the employment, but also depends on the terms within the employment contract. If the employment contract contains recall rights, which is generally the case for unionized workers, the maximum duration of the layoff will be specified in the contract. Otherwise, an employer must abide by the specific minimum standards, which are determined by the laws in each respective province or territory. For federal workers, the federal law must be followed. For example, in Newfoundland and Labrador, British Columbia, and Ontario, an employer can only lay off an employee for a maximum of 13 weeks in any 20-week consecutive period if certain conditions are met. In addition, in Ontario, a layoff can exceed 13 weeks if the length of the layoff does not exceed 35 weeks in any period of 52 consecutive weeks. Meanwhile, in Nunavut, a layoff must not exceed 45 days in a period of 60 consecutive days unless there is another period as determined by a labor standards officer. These minimum standards are clearly very different depending on the jurisdiction. Additionally, provinces or territories may change the layoff regulations during states of emergencies, such as during the COVID-19 pandemic. Taken together, layoffs are extremely confusing, and the rules surrounding them can vary drastically depending on the jurisdiction. Fortunately, my Open Courts layoff tool can help. With just a few questions, we can determine the legality of a layoff and empower you with the information to build your case.